Hello, welcome all to our webinar under the title of Can we increase the use of mediation through better use of dispute resolution clauses in contracts? I'll start first by introducing MediateGuru. MediateGuru is a social initiative led by members across the globe. The aim of this organization is to bridge the gap between general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future, having successfully conducted several webinars promoting alternative dispute resolution, having a reach in more than 60 countries around the globe with an international family growing day by day. We strive to provide you with the best lecture series through the best international speakers around the world so that you can have additional value today. As for today, I feel honored to introduce our self-esteemed speaker, Ms. Rachael Bicknell. Ms. Rachael is the founder of Squaring Circle, which is a specialist dispute resolution business based in Edinburgh, Scotland. She is the winner of the NMA Mediation Newcomer of the Year 2020 award. On the national level, she is a Scottish lawyer, a CEDR, and a Harvard-trained negotiator and practicing mediator. She is an online certified mediator and ADR ORD International accredited online mediator. She mediates and negotiates a wide range of commercial and civil disputes. She is also a specialist mediator panel member of the Professional Negligence Lawyers Association. Formerly, she was a dispute resolution solicitor in commercial law for 12 years. She is a mediation member of the Chartered Institution of Arbitrators. She is an accredited specialist in professional negligence law from the Law Society of Scotland. She is also a regular contributor of articles and trainer on negotiation, mediation, and online dispute resolution. So thank you all for joining our webinar today. Without any further delay, let us begin. Ms. Rachael, I would request you take the lead and enlighten us all with your knowledge. As for the participants, don't please forget to ask your question in the chat box.
Diana, thank you very much. I'll just check, first of all, can you hear me? Hopefully you can. I think there's maybe...
Yes, I can hear you well.
You can. Good, yes. Thank you. Okay, well, thank you so much for that lovely introduction and welcome. Good afternoon to everybody from Edinburgh in Scotland. It's a sunny day, a very autumnal but sunny day. And thank you to MediateGuru for hosting this event. I think there were 1,300 people registered from 60 different jurisdictions across the globe, which, as I was saying to Diana earlier, that's quite remarkable. And it's a testament to the vision and drive and innovation of MediateGuru and its founders. So, as I say, I'm absolutely delighted to be speaking to everybody today. I should say at the outset, my experience is focused primarily in Scotland, which is where I do most of my practice. I've done some in England, and I do primarily civil and commercial disputes, usually disputes that are being litigated. I have also been involved in a small number of community mediations as well. So whilst my experience is sort of restricted to this geographical area, hopefully those of you in all those other jurisdictions will take something away from today's webinar. I've certainly enjoyed the MediateGuru webinars over the last few weeks and few months, where we've had speakers, international speakers. It's been great to learn about what's happening with mediation in other jurisdictions. I think it's an important part of how mediators and those involved in dispute resolution can learn from each other. So for years, many dispute resolution lawyers in Scotland, myself included, have been beating the mediation drum, seeking to change the mindset of those perhaps hardened litigators, as they sometimes refer to themselves, who promote a more traditional courtroom culture. Now, obviously, as we all know, the COVID crisis has put mediation, particularly online and remote mediation, in the spotlight. And, until March, mediators and lawyers in the UK would just never have considered mediating disputes online, particularly commercial disputes, which are sort of seen as higher value. It just wouldn't have happened. It was very much the standard practice to mediate face to face, as I'm sure it is in other jurisdictions, with everybody coming together in one venue for the mediation day, which, as we know, for commercial disputes could run well into the night. Those of us involved in commercial mediations will know that you usually set aside a full 12-hour day, and it's not unknown to tip, as I say, into 12 plus 15 plus hours for a commercial mediation. But we're now in a very different world. Probably for the first time, we are seeing the global dispute resolution community of mediators and arbitrators, litigators, and others widely promoting mediation as an effective and appropriate way of managing disputes, particularly the huge surge that we're seeing in litigation. There's more litigation now due to the COVID crisis, and the backlogs in civil justice systems across the globe are struggling to cope with this. I actually heard this week, I watched Richard Susskind doing a presentation, and I'm sure he said something like 80 million cases in Brazil are waiting to be heard within the court system. I mean, that's just incredible, isn't it? So we are now seeing multi-million-pound disputes being mediated remotely online in the UK. Now, to put what I'm going to talk about today into some context, in Scotland, we are sort of stuck in a tunnel, coming up to a crossroads when it comes to mediation and alternative dispute resolution. The uptake of mediation in Scotland is comparatively low as compared to many other jurisdictions. So in the last 2 years alone, in Scotland, we have seen a Scottish Parliament Justice Committee report called I Won't See You in Court. We have had a Scottish mediation report with the title of Bringing Mediation into the Mainstream in Civil Justice in Scotland. And we've also had a proposed Mediation Scotland bill, which, if passed, would become legislation in Scotland. And all of these have recognised the need for a culture change to normalise the use of mediation in Scotland. It's still not seen here as part of the justice system. Now, there may soon be some light at the end of that tunnel. The Scottish Government plans to consult on the proposals in the Scottish Mediation Report. In a nutshell, that report makes very bold and, in my view, necessary recommendations to introduce an element of compulsion to mediate. So it is possible that we will see legislative changes in Scotland to promote the use of mediation in civil cases. As I said, about putting this into context, there may well be people listening in today in other jurisdictions. So in the US, which certainly in the UK we consider to be probably the most litigious society on the planet, and mediation is used very effectively to resolve civil and commercial disputes. So I think around 98% of litigated cases in California are settled by mediation. Now, we might say, well, that's only one of 50 states, but 55% of all civil and commercial claims in the US are actually filed in California. And some of the figures that I found when I was looking into this, that was something like up to 35,000 cases a year go to mediation in LA alone, in Los Angeles. So that is very remarkable, sitting in Scotland and looking at how mediation works here. So there's certainly a clear culture of mediation in the United States, which is simply not the case in Scotland. In England, as many of you will know, the civil procedure rules incentivise mediation, as a judge can make an adverse costs award against a party if they have been deemed to have refused a reasonable offer to mediate. So again, in mediation, in England, mediation happens at a far earlier stage in the life cycle of a dispute than it does in Scotland. As we heard a few weeks ago from Jennifer Esgard, on a MediateGuru webinar, in some regions in Ontario and Canada, mediation has actually been a mandatory and automatic stage in the court process for 20 years. And that seems likely that it's going to be extended to the whole province following support from the Ontario Bar Association, which I know that Jennifer was involved in, and various other legal groups. So this is maybe a very long-winded way of introducing the topic I want to speak about today, but why does all of this matter, and why am I looking at what other jurisdictions are doing? Well, it matters because in places like Scotland, where there is no automatic mediation process like in Ontario, where there's no culture of mediation being a sort of mainstream way of resolving disputes like we see in the US, and where there are no incentives to mediate like the civil procedure rules in England, it's often very common for one party to advocate for mediation, but in reality, getting all parties round the mediation or negotiation table is very often a negotiation in itself. Now, this is problematic, as we all know, for a number of different reasons. Access to civil justice is obviously a major issue at the moment, particularly in the COVID era. In Scotland, we have no court powers in relation to mediation, other than for low-value disputes under £5,000, where a judge can refer cases, or at least make a very strongly worded suggestion to the parties that they mediate through a voluntary court system. We have a panel of voluntary mediators, but that, otherwise there are no court powers. So that, combined with a culture in the legal profession which generally at the moment still leans towards litigation, we have a particularly difficult time where, as I say, one party may want to mediate and the other party refuses. And often, in my experience, we're seeing this as a sort of tactical move to almost create a power imbalance between the parties. So Scotland, like many other jurisdictions out there, is still waiting for some sort of legislation to support more use of civil disputes. Now, this is, before I go on to speak a bit more about dispute resolution clauses, I'd be quite interested to get the views of the people that are listening today. I've got some polls. I don't know whether those questions can be asked now for the polls.
Yes, ma'am, for sure. Ma'am,
Thank you.
Ma'am, which one?
If you do, so I think if we just do all three just now, if people are able to answer.
Ma'am, it will go one by one. So okay. If you can, just tell us which one first.
Perfect. Be quite interesting.
I'm sending the first one right now. It's live. You can see in the poll section.
Yes, so the first one, have you drafted alternative dispute resolution clauses into contracts? So this will be interesting. So that's probably, oh, there's still some people doing it. Okay, so if we end it there, we've got roughly 1/3 of the people participating say yes and 2/3 say no. And are you able to do the second poll? Oh, not that one. Here we go. Have you been appointed as a mediator as a result of an alternative dispute resolution clause in a contract? Okay, so we'll end that there roughly. So just over 10%, 13% of people have, and 86% of people have not. And the last poll, please. Have you been appointed as an arbitrator as a result of an ADR clause in a contract? Now this, I wanted to see if there was a difference between arbitration and mediation. There may not be that many arbitrators on the call today, on the webinar today, of course. Okay, so again, quite a similar split. We've got roughly about 10% of people have, and about 90% of people haven't. So thank you very much for doing those polls. So for me, that's really quite interesting, because the main part of what I want to speak about today is what I've sort of termed the secret weapon that contract drafters, such as transactional lawyers and in-house lawyers and business leaders have. And this sort of secret weapon at their disposal, I suppose, is inserting dispute resolution clauses into contracts. So a dispute resolution clause, or sometimes called an alternative dispute resolution clause, sometimes also called a multi-tier dispute resolution clause, is actually one of the most vital provisions in a contract. And it gives the parties to a contract an opportunity to set out, as part of the contract, how a dispute will be resolved in the event of a dispute arising. Now, I don't want to turn this into a legal seminar. These are often boilerplate clauses in contracts. When the contracts are being drafted, disputes and the processes that can be used to resolve disputes are often not given appropriate, or in fact any consideration at all. And as I say, the DR clause allows the parties to agree within the contract the process to be followed in the event a dispute arises. And there's much to be said for agreeing how a dispute will be dealt with while the parties are on good terms, because as we all know, once a dispute or a disagreement arises, parties are usually less willing to adopt a collaborative approach to the process of resolving their differences. And as I say, in my experience, it is so common for perhaps one party to say, we should mediate this dispute, but it can often be very difficult to get the agreement of the other party or parties. So how these clauses work, I'll just talk a little bit about how they work and what they achieve, and then we'll actually have a look at a dispute resolution clause, and then I'm going to discuss just very briefly some of the cases that have come out primarily from the courts in England in relation to the enforceability of these clauses. I mean, in my view, dispute resolution clauses are particularly for countries like Scotland, where as I say, mediation remains a completely involuntary process. These are hugely important for parties to control, whilst everybody's on amicable terms, to control how any dispute will be dealt with and the process that will be followed. So how these clauses work usually is for a claim to be escalated in stages. So typically, parties will first be required to engage in negotiation at different levels within each party's business. And so that might start off at a lower level in the business. It may be that somebody at managerial level on each side of the parties first needs to try and resolve a dispute, and then it gets escalated perhaps to director level, and then perhaps to CEO level. And usually then the clause will require mediation as a precondition to arbitration or to litigation. And often the clauses will go further, and they'll actually name the organisation from which a mediator and or arbitrator must be chosen. So that again prevents any further potential for disagreement and delay when it comes to the point of choosing a third party neutral. And when we look at some of the cases later on, this is actually quite an important part of a dispute resolution clause. So I thought it might be helpful to look at a dispute resolution clause. I'm just going to share my screen and hopefully you can see, oh, sorry, wrong one. Hopefully you can see this. So this is the model dispute resolution clauses for squaring circles, which is the business that I have founded. And many of you may be mediators with other organisations. So all the big named UK mediation and ADR providers have model clauses. CEDAR in England, and in place of Strife, now known as IPOS, they will have them. Core Solutions in Scotland also have them. I'm aware of lots of providers around the world who have these clauses. Effectively, they set out what the parties are agreeing to a dispute. So the first one is a multi-tier dispute resolution clause, and it does exactly what I just described, whereby to start with, you'll see here the parties agree to appoint an authorised representative to attempt to resolve the matter by way of negotiation within 14 days. If the dispute is not resolved through direct negotiation between the parties, authorised representatives, the parties first agree to participate in online mediation. This is where it then talks about where the mediator will come from and the process that will be followed, and then it sets in specific time limits for things to be progressed, when the mediation will start after the mediator being selected. If the parties don't agree on a mediator, then the organisation will appoint a mediator. And again, this dispute resolution clause then chooses arbitration as opposed to litigation. I'll send links to these clauses after the webinar, or MediateGuru will send links to these. And as I say, you can look at clauses from other organisations as well. And then here we've got simply an arbitration clause, where for certain disputes it may be deemed more appropriate to have perhaps only arbitration. I personally think having a mediation clause in there as a precondition to arbitration is always the best way to proceed, but there may be specific reasons for certain types of disputes where an arbitration clause might be more suitable. So I'll just stop sharing my screen. Sorry, I'm still getting used to this. So that was an example of as I say, a multi-tier dispute resolution clause, whereby you have first negotiation where the parties are legally bound to seek to negotiate first, then the dispute is stepped up to mediation as a precondition of, in that case, arbitration. Now that's just one example. Dispute resolution clauses, as I say, traditionally, and as we can all see from how much they're actually used or how much of us have experience of them, because they're not traditionally perhaps given the attention that they should be given, I don't think people really realise how broad and how wide and how much a dispute resolution clause can cover. So it's possible to cover a huge number of variations and options when it comes to how a dispute could be resolved. So, for example, it's possible to allow mediation or specific dispute resolution processes. You could restrict them to certain stages of a project that's governed by a particular contract. It's also possible to say that mediation could progress, for example, in parallel with litigation proceedings. So there's a huge amount of option in terms of how you draft the clauses. What's important is that they include there's certain things contained within the clause, so that if you do need to seek to enforce that clause at some stage, which I'll talk about in a second, that you're able to do that. So as I say, multi-tier dispute resolution clauses, also sometimes called dispute escalation clauses, certainly in my experience are increasingly being used by businesses and enterprises and organisations across a broad range of sectors and across a very wide range of contracts to assist with resolving disputes quickly and efficiently and cost effectively, and also actually thereby preserving the contractual relationship, because as we know, mediation and a collaborative approach to and early engagement to a dispute is far better to preserve that contractual relationship than ploughing on with court proceedings. So there are very obvious practical and commercial benefits to an alternative dispute resolution clause that encourage the parties to come together at an early stage, support a collaborative approach to dispute resolution, and preferably before it becomes a very costly and time-consuming process. As I've said, these clauses also give greater control of the dispute to the parties involved, and frequently allow these parties to mend a commercial relationship or deal with it before it's broken, so that they can carry on working together. So, as I've said though, even although there may be an ADR clause in an agreement, you may find that one party may seek to raise sort of formal court proceedings, either without checking a contract to see if there's a dispute resolution clause there, or perhaps as a way of circumventing what the contract might say and ploughing on with court proceedings in an attempt to cut out any agreed settlement stage that's set out in the contract. And so the party who, I suppose, is wronged by that may consider that it needs to go to court to try and enforce an alternative dispute resolution clause as a condition precedent. And I would like to think that as these clauses are used more frequently, as certainly in England, I think that they are being used more and more often. In Scotland, they are to a degree. I would like to think that there would be we'll see less challenges to these types of clauses in the courts. I should say that there's actually no reported decisions in Scotland on the enforceability of these clauses, which is perhaps an indication that they're used not nearly enough. But there have been a number of decisions in the English courts over the last 20 or so years where parties have actually been prevented from progressing with court proceedings, where a dispute resolution clause has created a contractual obligation to engage in mediation as a condition precedent to litigation. And there's no reason to believe, whilst Scotland and England have very different legal systems, there's no reason to believe why the Scottish courts would have decided these cases any differently. And whilst these cases are, as I say, are all from English courts, hopefully they will be helpful to those of you operating in other jurisdictions. I do have a couple of slides for this part of the presentation, which I will just share my screen and find. So, hopefully you can see this. So, as I say, there has been a number of decisions from the courts over the last few years. This is probably the most important case that's come from the commercial court in England. So it's Cable and Wireless against IBM UK. I put the citation on it, and again, I'll circulate these in case anybody's interested in reading these cases. But effectively, in this case, the court decided that a contractual agreement to refer a dispute to alternative dispute resolution could be enforceable by ordering a stay of the court proceedings. And there was a number of principles that the court set down in this case. These principles are what a court must take into account when a party seeks to enforce an ADR provision. And so this is what the court said. The agreement must create an enforceable obligation requiring the parties to engage in ADR. The obligation must be expressed clearly as a condition precedent to court proceedings or arbitration. The DR process to be followed does not have to be formal, but must be sufficiently clear and certain by reference to objective criteria, including machinery to appoint a mediator or determine any other necessary step in the procedure without the requirement for any further agreement by the parties. So these three principles are obviously very important when you're drafting your dispute resolution clauses, that if they are not clear and concise, and if further decisions and agreements need to be made to give effect to these provisions, then there's a very real risk that a court will say that these are not enforceable. And the last point is that the court has discretion to stay proceedings commenced in breach of an enforceable dispute resolution agreement. And in exercising its jurisdiction, the court will have regard to the public policy interest in upholding the parties' commercial agreement and furthering the overriding objective in assisting the parties to resolve their disputes. So this was, as I say, this is sort of the main case that you should look at when drafting these sorts of clauses or interpreting clauses for the lawyers out there, interpreting dispute resolution clauses. There are a number of other cases, and so I've given a kind of a selection here of where the courts have held these clauses to be enforceable and where they haven't. So, Open Operations UK against Invesco fund managers. That was a decision from the Technology Court in England from 2019. I can't remember what the other it's Technology something court. And that heard that the parties' agreement to mediate was legally enforceable. It was a condition precedent to commencing legal proceedings, and the court ordered the proceedings to be stayed. And they referred to the cable and wireless decision that we've just discussed. And that case was very similar. There are some older cases I've listed here, one from 1989. This was in relation to a clause saying that any dispute in this agreement will be settled amicably before it could be arbitrated, and the court just held that that was unenforceable, and that was probably not a surprise to us. Again, Walford against Miles in 1992, a bare agreement to negotiate was too uncertain to be enforceable, and that a duty to negotiate in good faith was unworkable in practice and inherently inconsistent with the position of a negotiating party. And again, the lawyer in me is not surprised by that decision. We have a case from 2012. This is in relation to an insurance policy which stated that the parties would seek to have a dispute resolved amicably by mediation. And again, it didn't create an enforceable obligation to commence or participate in a mediation process. And again, if we look at the criteria that was set out by the court in Cable and Wireless from the 2002 decision, that doesn't contain any of those those necessary principles, I suppose, of what needs to be set out in a mediation clause. Clearly, a number of other matters would need to be agreed by the parties in order to give effect to this requirement to resolve a dispute amicably by mediation. And just another few cases, because I am conscious that this is sort of maybe turning into a bit of a legal seminar. The Grant Thornton case, this was a clause which set out a step to first refer the dispute to a panel of 3 members of a partnership. And again, the court said that that just wasn't sufficient. Emirates Trading, a clause which required the parties to seek to resolve a dispute by friendly discussions and in good faith within a limited period of time, was enforceable before sending it to arbitration. So that's quite interesting. And the last case I refer to, Anzen, and this was a shareholders agreement that stated that any party may submit a dispute to arbitration. Again, it was held not to be enforceable because a clause depriving a party of the right to litigate should be clearly worded, and may submit a dispute to arbitration is obviously quite different from shall submit a dispute to arbitration. So the court held that that provision just wasn't enforceable. So as I say, I'll send these cases out, or I'll ask MediateGuru to do that. Let me just turn off my share screen. So that really brings what I had to say to an end. And as I say, hopefully those of you in other jurisdictions have found that at least a little bit interesting, and hopefully quite useful as well. And Diana, if there's any questions, I'm very happy to answer any of those.
Thank you, Ms. Rachel. We will take some questions from the audience. The first question: does the doctrine of separability of clause apply to mediation clauses like it does in arbitration?
Sorry, could you repeat?
Does the doctrine of separability of a clause apply to mediation clauses like it does in arbitration?
I have to be honest, I'm not entirely sure I understand the question. Separability.
Yes, separability. No, does the doctrine of separability of a clause apply to mediation clauses like it does in arbitration?
I'm afraid I probably can't answer that question because I'm not entirely sure what separability of clauses. Separability, did you say, or severability? Yes,
No,
sorry.
separability.
If you,
We'll take
I'd be happy for you to put me in touch with the person who asked that question, and
yes.
I can have a bit of a discussion about it. Apologies, I'm not sure what that doctrine actually is.
Yes, don't worry. We'll take another one. If both the lawyers are settlement-minded, then why should we hire yet another professional as a mediator? Does it make any difference if we do so?
Well, it does, in my view. So, I'm a mediator, but I also still do some legal consultancy work. So I still operate as a solicitor, and I still, recommend mediation to the limited number of clients that I now work with. If you assume that you have two collaborative lawyers, then if you have two collaborative lawyers, certainly in Scotland, you would be very lucky, probably still to be in a position whereby disputes arise where mediators are simply not required. Mediators bring in a completely different dynamic, and they enable parties, even where there's collaborative lawyers involved on both sides, they enable parties to have facilitated negotiations that may still be difficult to have solicitor to solicitor, because the discussions are confidential between each of the different parties, and the negotiator, the mediator helps to share information as part of that negotiation, which, as I say, may be difficult to share lawyer to lawyer. So there's definitely still scope for mediators where you have collaborative lawyers. Of course, we often find that even if you have collaborative lawyers and you resolve a dispute later on and further down the line, mediation is an opportunity to resolve the dispute at an earlier stage. And actually, whilst you are paying for a third professional to be there, certainly in my experience, anecdotally, there's a lot of published figures around this, that mediation will actually most likely save you costs in the long run, particularly if you mediate earlier on in the life cycle of a dispute. Certainly in Scotland at the moment, this is one of the issues that we're facing. Mediation is often happening 3 weeks before a civil trial date, or 3 months before a civil trial date. In England, mediators I've spoken to, and anecdotally what I've heard is that mediation happens at a much earlier stage.
Okay. So the next question: what things one must know about the Singapore Convention?
Sorry?
What things one must know about the Singapore Convention?
What things do we need to know about the Singapore Convention? Well, lots of things. I mean, obviously, I know that MediateGuru have done a separate seminar on that already, so I probably don't want to talk about it too much. I think that seminar might be available on your YouTube channel. It's obviously now in force. It's very important when we're looking at cross-border disputes, because it now makes it easier to enforce resolution agreements in one jurisdiction, makes it easier to enforce them in other jurisdictions. So for that reason, it's very important. But I would probably not want to open up a whole discussion on that, and would direct you to, I can't remember who did that. I think it was the first MediateGuru seminar. So I think it's definitely worth watching that on YouTube.
Yes, definitely. How it is enforceable if the agreement contains that before going to arbitration, the party will be at liberty to resolve their dispute amicably.
Sorry, could you repeat that?
How it is enforceable if the agreement contains that before going to arbitration, the party will be at liberty to resolve their dispute amicably.
So I think the question is asking, would that be an enforceable provision? And I think possibly not would probably be the short answer. It would need to the dispute resolution clause should probably, in that situation, in my view anyway, set out a bit more detail around what would be required as a starting point. So by simply saying the parties will seek to resolve their dispute amicably before referring it to arbitration, I think probably would fall short of the principles that were set out in the cable and wireless case. I'm not sure if that answers the question.
So we have another question. Do you think that litigation is going to be replaced by alternative dispute resolution?
Do I think litigation is going to be replaced by alternative dispute resolution? I don't think litigation will be replaced. I think that a very important part of the rule of law and civil justice is that we have recourse to a court of law, and that's not going to change. I certainly think in Scotland, anyway, that in many cases the default position remains to go straight to raising court action. And I think that it's often in the interests of the parties, probably usually in the interests of the parties, to explore alternative dispute resolution and to consider mediation. At the end of the day, mediation is a voluntary process in the sense that even if there's a degree of compulsion to mediate, which we don't yet have in Scotland, but even if there is, parties are never bound to reach a decision in a mediation, and they should be entitled to refuse to reach an agreement in mediation if it's not in their interests to agree what is effectively available to them, and they should still have the right to pursue their claim in court. But I certainly think that mediation is gaining a huge amount of attraction on the global stage at the moment. Certain countries and jurisdictions are obviously 20 years ahead of Scotland, for example. But even in Scotland now, we've just had a public statement issued this week by a number of leading law firms in Scotland saying, we think that organisations, businesses, the government should be making greater use of mediation. So I definitely think we will see more of it. And I think often it's in the best interests of the parties to reach a resolution that way.
Okay. So here's an interesting question. What are some important tips you suggest to those freshers in the field of commercial mediation?
Tips for which people, sorry?
The freshers in the field of commercial mediation.
Tips for people, I think, who are just starting out in mediation. So certainly in my experience, you get your mediation qualification, and I think it's very important for people to, if you have an interest in mediation and dispute resolution, there's a huge community out there, and mediation is a very supportive community, as you would expect. It's very collaborative. There are people that you can follow on LinkedIn and on Twitter. I certainly follow a lot of international mediators and mediators that work in the UK as well. I think that if you got your mediation qualification, which is really probably the first step to a career in mediation, you then can look to organisations who are perhaps looking for volunteer mediations. I mean, ultimately, it's about building up your mediation hours and the time that you spend mediating. So you may start as an observing mediator, you may then be able to do some assistant mediating work and assistant mediating opportunities. If you do your training with certain training providers, they then allow you to join panels where you may be invited to assistant mediate. And as I say, it's really just growing your network with mediation people and getting as much mediation experience as you possibly can.
Okay, so the last question. Is there a specific checklist to draft a good multi-use ADR clause?
I'm not. There may well be something out there. I haven't come across anything like that. I think the main thing would be to look at the cases that I've referred to as a starting point, and as I say, there's a number of probably styles clauses that are available online that you could look at and pull together. There's quite a lot of resource, obviously, on the internet, and as I say, there's a number of organisations that have their own sort of model clauses. So, but the case law, I appreciate that it's difficult these cases are the English cases. It's difficult if you're in other jurisdictions. You may want to see what case law is available for the jurisdiction that you're in. That would definitely be my starting point.
Okay, thank you, Ms. Rachel, for such an interactive, knowledgeable webinar. I am sure that all the participants have benefited from your knowledge and experience. As for the participants, please don't forget to fill the feedback form sent in order to receive your certificate. So thank you everyone for joining us. If you don't want to miss any update from MediateGuru, make sure you follow us on our social media platform and to join our WhatsApp update group in order to receive every update. Stay healthy, stay safe. See you soon. Goodbye.
Thank you very much. Thank you.
Goodbye.